Oh, shoot. Hello, everyone. Welcome back. This time for Barbour's MGov, long story short, chapter 3. This one on civil liberties and civil rights. Like the videos you've seen thus far, I'm going to stick to the text pretty closely um, for lots of different reasons. Let's dive right in, though, and I'll explain, though, how this is relevant to the upcoming film you will be able to watch this week and next. Anyway, let's think about this. Introduction to Civil Rights and Civil Liberties. Aren't rights and liberties the same thing? Right? I think the use of the word civil might throw us off. Um, but ultimately, civil rights and civil liberties, while conceptually we put them together, they're not exactly the same thing. I actually like on the second page, right at the start of chapter 3, if you've got the paper book or the online version here, there's a little blip that says in a nutshell. And I like it. I like how she explains, how Barbara explained, the civil liberties are rights that come from the limitation of government power. By contrast, civil liberties are individual rights that come from the limitations of government power. By contrast, civil rights empower government to give rights to groups of people who share common characteristics. You could say civil liberties are about equal protection from the law, and civil rights are about equal protection of the laws. So liberties are, in effect, what you're free from the government doing to you, right? And rights then are again what the government is. Civil rights empower the government to give rights to people. So rights are what you can do, and liberties are what you're free from the government doing to you. I realize I haven't explained that as clearly as possible, and as many times as I've taught civil rights and liberties, I never seem to hit the nail on the head. But there it is, right? Liberties, as the root implies, liberty is freedom. You're free from government intervention, and rights are what you can do, what the government can't stop you from doing. So, yeah, I hope that's pretty clear. Either way, both of these are essential for non-authoritarian societies, right? You can't really have a democracy with people with individual freedoms and rights without rights and liberties, right? I mean, I just said it: freedoms and rights, rights and liberties. I mean, I'm saying the same thing. We often think of the Bill of Rights, and the Bill of Rights we use this term Bill of Rights, which, as we talked about last time around, was needed to pass the Constitution to buy the favor, if you will, of the anti-federalists. The Bill of Rights actually includes both rights and liberties. So they're very important nonetheless in practice, right? But yeah, fuzzily defined, distinction between the two. But this isn't law school, and I'm not going to ask you to write an essay distinguishing rights and liberties from each other, so don't sweat it. Let's revisit the Bill of Rights very quickly. Remember that these were the first 10 amendments to the Constitution. We've talked about this already. They were demanded by the anti-federalists, who were worried exactly about government power, federal government power being too concentrated and too strong. And thus the Bill of Rights was meant to clarify what individual rights existed and what the government couldn't do to us, right? So that's where we're at. So the Bill of Rights is a good thing, correct? Alexander Hamilton, who was, of course, remember, a hardcore Federalist, he often thought that the Bill of Rights would maybe empower future governments by intentionally giving them more power. Which is to say that a future government might be able to say, well, this isn't covered and that's not covered in the Bill of Rights. So, a tyrannical Congress or something could start making laws that would ultimately infringe on our freedoms, our liberties, and our rights. Right. The safeguard there as well safeguards are found as well in the 9th and 10th Amendments, which were really meant to strengthen states' power and interest vis-a-vis the federal government. And are really the foundational documents of the federalism that we have today. So, I mean, I understand Hamilton's skepticism, and I'm going to come back to it toward the end of the slideshow here. But I think ultimately it was a pretty good thing. I mean, it really has to do with the origin story of rights in the United States and the importance of political narrative. And I put this in bold and italics here for a reason, right? Chapter 1 of the text really began and ended talking about the importance of political narratives. And political narratives are going to be important in the next couple of weeks of the class to keep in the back of your mind, right? So, I mean, that we have this Bill of Rights and we all learn about the Bill of Rights in school, whether it's primary school, high school, now in college, should tell you that these are pretty important, right? And we know that they're based on natural rights, which going back to Thomas Jefferson and the Jeffersonian notions of natural rights, that means these are given by God, right? In Jefferson's mind. And these are the ultimate protection against authoritarianism. And it's also, we also talk about the rights as I'm doing right now in the early 2020s here about the importance of such things, but they weren't applied equally, right? So we can tell ourselves how wonderful the Constitution is, and how wonderful the Bill of Rights is, and how how obviously democratically minded the founders were, but we know darn well, that these rights weren't applied equally, right? So while they do provide us ultimate protection against authoritarianism, we need to remind ourselves again that the political narrative that we're socialized to learn at an early age didn't really work in practice. And this is going to be a theme for the slide, so I'll not repeat myself now. I'll repeat myself in a bit. Are Americans' constitutional rights unlimited? Sometimes I see people with T-shirts and such that might imply otherwise, that their rights have no limit, but in effect they do. Our rights are limited when they clash with others' rights, and they're limited when they conflict with the collective good, right? So, I might have a right to bear arms, but I don't have the right to go kill people, right? People have a right to life, a right to live, and not be shot by stupid Professor Larson. And then obviously, too, we have, say, freedom of speech, but we can't go around and yell fire in a crowded theater, right? That goes against the collective good. That puts people in danger, unless there actually is a fire, of course, right? So again, our rights are good things. That's pretty difficult to argue against, but they're not unlimited, right? So whose behavior is the Bill of Rights meant to limit? The national government and Congress, first and foremost, right? And again, the 9th and 10th Amendments make it pretty clear that there really aren't limits for states. The 10th Amendment says almost verbatim that anything not covered in the Constitution as an obligation, right of the federal government to decide upon is left to the states. So that's why the vast majority of laws that apply to our daily lives, whether that's traffic laws, most of your run-of-the-mill criminal law, public education, professional licensures, like there's no federal document that says, hey, you're a dentist, or a lawyer. You got to pass the bar or the dentist test, whatever that is, in whatever state you're in, right? So a lot of what's handled bureaucratically in this country is done at the state level. And that has a lot to do because the national government and Congress were limited in what they could legislate on collectively. Congress is part of the national government, but beside the point, the Constitution limits their margin of operation. We'll put it that way, leaving a lot of room for states to decide the day-to-day laws that affect most of our lives. Right. Along the way, the Supreme Court has grabbed power from the states to make the states enforce the Bill of Rights, and this goes back to the post-Civil War era. And again, this is very relevant to the film you're going to watch soon, hopefully, that's called 13th. That's about the 13th Amendment, which abolished enslavement. The 14th Amendment was meant to ensure rights for the the formerly enslaved people at the time in the 1860s. But it took really the Supreme Court a lot of decisions to be made that, in effect, forced the states to incorporate the provisions of the 14th Amendment into state law. Congress couldn't make them do this necessarily, but rather the Supreme Court interpreted the 14th Amendment in ways that the states did not. The Supreme Court eventually basically made states incorporate the 14th Amendment into their legal structures, ensuring nominally, right, on paper, equality among all citizens within their state, right? And I'll come back to this in a minute. Let's think about civil liberties here rather quickly, understanding the First Amendment. The First Amendment includes like 5 different kinds of freedom, right? Freedom of the press, freedom of religion, freedom to assembly, freedom to protest, freedom to petition the government, right? We can criticize the government and we don't go to jail for that. But the first of the First Amendment clauses is that of the freedom of religion, right? There's the Establishment Clause, which says that Congress can't declare that there be a national church of any kind or national religious institution of any kind, and then it simultaneously acknowledges that we have the free exercise of religion. However, within that, we see and have seen since over the last 240 some years an inherent contradiction in the application of religious freedom, right? States might not be able to create their own religious institutions, but they're often very religious people who get elected into office, right? Who might want to legislate how they feel about things based on their religious leanings, and that might impede our individually our exercise of the freedom of religion, right? So there's inherent contradiction there that has never completely been resolved. Why was that tension written into the Constitution then? Because through the amendment process. Well, because the founders were pretty skeptical. Most of them were religiously minded people. They were at the very least deists. They believe like Thomas Jefferson. He was rather critical of religion in general, but at the same time, he believed in God. That's why he thought, these inalienable rights were God-given. Natural rights were God-given. So the founders, found it difficult to compromise religious differences. And keep in mind, too, at the time of the founding, pretty much all of the 13 colonies didn't have an official religion necessarily, but they tended to attract practicants of the religious people who were there. So like Maryland, for example, Maryland, this was more or less the Catholic state upon the founding, right? Pennsylvania was the Quaker state, so on and so forth. So you had a lot of different Protestant Christian interests at the time, and it was difficult to reconcile those. The founders also had experienced difficulty resisting a religious government, or at least the original settlers, right? That's what motivated people to come. That's what we learn in history class in primary school and secondary school, that the original colonists, colonizers, if you will, probably a better term, who came by boat from the UK, but many of them were originally from Holland and were fleeing religious oppression, right? So there was a desire to maintain a separation between church and state. Now, how that's played out for the last couple hundred years and change has been perhaps less neat and perfect than our founding fathers envisioned. But we'll talk more about this here, well, on my very next slide. So by 1971, so still we're looking at nearly 200 years after the ratification of the Constitution, we finally get a true test of the separation of church and state in this case of Lemon versus Kurtzman, details about which you can Google on your own if you're really interested. But it really boiled down to a disagreement between what were called the accommodationists, which were those who thought that the state should do more to accommodate religious beliefs of citizens, versus separationists, who viewed this wall of separation between church and state in a more literal fashion. So, as the Supreme Court tends to do, very ambiguously created what we call the Lemon test, coming from the name of the litigants in the case, to determine what is excessive entanglement on the part of the government. The details of the case were basically about prayer in school in Pennsylvania. And the Supreme Court decided, I believe, 8-1, so pretty overwhelmingly, that a public school could not disallow students from praying on their own, but no public school could force prayer on the students, right? So this was the excessive entanglement argument. So again, these are issues that have yet to be completely fleshed out. And again, I'm going to come back to these, to the question of religion here in a few slides. I think I've got about 35 slides today. So I'm trying to go at a decent pace, but without selling you short here. So let's think about free exercise of religion, which is the other half of this equation, right? The first half being the relationship between church and state. Congress is prevented from prohibiting free exercise of religion. Congress cannot pass a law that says we can or cannot, we have to or absolutely cannot practice any religion under the sun. Now, does this mean more freedom for some means less for others? This is where we're at today, right? The question of marriage equality, which has finally become law of the land thanks to a Supreme Court decision, was very much a religious controversy. And this is something that I very much grew up with in the 1990s when I was, a dumb teenager for most of that decade. Bill Clinton was president. Bill Clinton allowed um, uh, LGBTQ citizens to serve in the military as long as they didn't make their sexuality known. It was a policy called "Don't Ask, Don't Tell." Didn't really go very well, and it was repealed by the Obama administration years later. But Clinton also oversaw the Congress's approval of the DOMA law, which is the Defense of Marriage Act, which declared um, an act of Congress declared as federal law a marriage could only be between a man and a woman. And I believe that was passed in 1996, and Clinton signed it into law, and that was sort of the horse trading that went on between Congress and the president. Congress by 1994 was well in Republican hands, and Clinton was still president. So Clinton, to get Republicans to I guess, acquiesce to the "Don't Ask, Don't Tell" in the military. Um, it wasn't legislation, executive order. Clinton signed the Defense of Marriage Act. That was overturned, I want to say, in like 2013 or 14. And then that led to the decision in Obergefell versus Hodges, which is the decision that ultimately made marriage equality the law of the land in all 50 states, right? But you can't really disassociate, especially those who are against marriage equality, you can't really disassociate that from the question of religion, right? And for a lot of folks, a lot of our more religiously minded friends, rightly or wrongly, they view this as like a zero-sum game, that if other people gain what they view as rights that go in contrary to their religious beliefs, then they're suffering, right? They're the victims here. But I don't personally agree with that necessarily. But nonetheless, we're not here to argue the subjective concerns here. It's just a very good and very timely example of the First Amendment still being ironed out to this day, right? I mean, reasonable people can disagree on some of these questions, but it's instructive. Again, I will repeat myself that the First Amendment is still being fleshed out. We still can't say with great certainty exactly how it works in practice, right? And for some people, that's a great thing, and for some people, it's pretty frustrating. But moving on, the rest of the First Amendment, we can talk about freedom of speech, freedom of press, freedom of assembly, and again, the right to criticize government, the freedom of petition. So these are all pretty good things, right? These are things that pretty much all democracies around the world recognize. And we can even talk about countries that claim to be democratic that aren't as free in practice, still will tell you, oh, yes, we allow for these things, right? The founders definitely believed that we needed the freedom of expression, the freedom of assembly, which is in effect the right to protest, right? Freedom of assembly to gather, and the right to criticize the government, right? If free speech is so important, why do we ever limit it? Well, there are limitations, less so in the United States than some other countries I'm pretty familiar with, but there are protections. Speech is not limitless, particularly in times of war. We don't have a right to be blatantly obscene. Although maybe I might like that, I might appreciate that, but unfortunately I don't have that right. You don't have a right to, the law against fighting words is really a thing. You can't intentionally go out and aim to start a fight with someone to cause violence, right? You can't do that. And we can't just needlessly, with no proof, maliciously damage anyone's reputation, right? There are laws against libel, which is a written form of defamation, or slander, which is a spoken form of defamation. I can't go around saying student so-and-so is such a this, that, and the other, either in written form, that would be libel, or spoken form would be slander. I can't do that without any evidence, right? However, other countries do provide more protection than we provide in the United States, and I think this is because we've just got this individualist streak baked into our system, that you really have to cross lines, and you really have to talk out of your backside with no proof whatsoever to be convicted of libel or slander. And again, free speech has been put to the Supreme Court test again and again over the years, and the Supreme Court's basically decided that you can't go around causing clear and present danger. You can't incite imminent lawlessness with your language. Unfortunately, again, I can't be as obscene as I would like to. And then obviously there are laws against prior restraint, which is to say against censorship. The Supreme Court has really resisted any form of censorship by the government. And prior restraint is just another way, basically, of saying censorship. Sorry, that it's really tricky for the government to make a case to prevent, say, the publishing of something that someone in the government might find detrimental to the government itself, right? There are laws against sedition. We can't go around invoking rebellion against the government, but at the same time, it's really difficult for the government, the U.S. federal government, to censor whatever criticism we might have to say. And that meaning that's prior restraint, and that's been resisted by the court. The court has definitely shied away from authorizing any form of censorship on the part of the federal government. But however, be aware, there are looming issues on the free speech horizon. Barbour, the author of the book here, she makes the point, and I do agree. And this is, I don't like this book for some reason. I do like this book for other reasons. And she does do a good job of putting very old things like the Bill of Rights into present day context, which I appreciate, and I hope you do too. But we need to think about, say, the regulation of access, content, and censorship in the internet, access to the internet, content of, censorship of the internet. More precisely, perhaps, is the issue of net neutrality, which I'm sure some of you have heard about. It was in the news very intently, maybe 3, 4, 5 years ago, which I do understand for you guys, for you all is sometimes ancient history. But Congress has flirted with passing laws that state that, say, for example, any internet service provider cannot make choices about what you, the internet user and consumer, can access more easily or less easily, right? So the idea of net neutrality claims that, say, Verizon or Spectrum or AT&T or whatever crappy internet service provider you have, because they're all pretty bad. I think we can agree on that. And we have the freedom of speech to make that claim. But those providers can't decide that, oh, hey, Verizon can't say that it ever competes with Google, so it's going to reduce the bandwidth that you can use as the individual user to access, say, YouTube, which is owned by Google, right? So, Congress, again, has flirted with this, but for some reason, the big internet service providers, while they've yet to violate the notion of net neutrality, as far as I'm aware, they're not on board with signing off on this. I think the providers like to keep that card in the back pocket, just in case in the future. Who knows? But that will be probably the future fertile ground of debate when it comes to free speech, right? And of course, this is something that the founding fathers would not have envisioned at all, obviously, right? Add to this the notion of fake speech, fake news. I have a feeling there might be court cases coming down the pike in the next 5-10 years that have to do with the legalities of free speech or of fake speech, of disseminating information one absolutely knows or should know to be false. We're seeing this as a concern, obviously, in the age of the virus crisis, and we'll see what happens in the future. I can't really tell you what my gut says, but the Supreme Court will have to wrestle with this pretty intently. And I'll come back to this here in a sec if I remember to. But anyway, moving forward, why did the founders devote half of the Bill of Rights to due process, right? And by due process, we're talking about legal processes, right? So they crammed a bunch of provisions into one amendment, which was pretty important, the First Amendment. But about half of the Bill of Rights has to do with due process. And this was because, again, the anti-federalists in particular feared a strong government. They feared that a strong government might deny habeas corpus, which is a Latin term, and I forget exactly how it translates, but it's your right to a fair trial, a speedy and fair trial, right? You can't be arrested by the government and then held indefinitely, unless you're in Guantanamo Bay or something. It's a joke, and it's totally not. But you and I, normal folks living in the United States, citizens or not, and I'll come back to that in a sec, if we're arrested, we have a right to know what the charges are. That's habeas corpus. And I believe habeas corpus was only once denied or suspended in the United States by Abraham Lincoln during the Civil War. There are amendments to the Constitution against bills of attainder, which are bills that would be written and drafted by Congress meant to make illegal something that certain groups within the country do with the intention of sending certain people to jail. So they can't, Congress can't write laws that meant to target certain people to punish them. It's not randomly, but because of who they are, what they do. Beyond that, there are provisions against ex post facto laws, which is more Latin, which basically says Congress can't pass a law to make something illegal after the fact you've already done it, right? So, Congress could hypothetically pass a law that makes something illegal that you did yesterday, but if you did it before the law was passed, you can't be punished for that, right? So Congress can't go around basically making, both of these things have to do with Congress making laws that would weaponize the legal system against certain people, and that can't be done. That's the due process, part of the due process provisions in the Bill of Rights, right? What other due process rights can we identify? The government needs probable cause to search your home, right? They can't do it without a warrant. It has to be a reason. You have to get a court to agree. There's a right to know the reason for arrest. That's habeas corpus again. There are protections for trial, counsel, and imprisonment, right? You have a right to be represented by counsel if you're brought up on charges by the federal or the state government. And then years, decades, centuries later, we get the Miranda rights, the Miranda case, which I believe goes back to the 50s in Arizona, where, of course, you have the right to remain silent, so on and so forth. That's an extension of the Bill of Rights. You don't have to incriminate yourself when you're arrested. And then, of course, we know that the Fifth Amendment also precludes us from having to testify against ourselves in court, right? That's I plead the fifth. That's what that is, right? So these are due process laws, right? They work great, except when they don't. It took the Supreme Court until 2001 to decide legally to make it settled law through judicial review that non-citizens are entitled to civil rights. So my wife, for example, who's not a U.S. citizen, has the same civil rights that the rest of us do here, whether you're a citizen or not of the United States, right? If you're a human in this country, according to the Zavidas versus Davis ruling of 2001, we all have the same civil rights. Now, again, they work except for when they don't. The Barbour textbook here, while, I think in chapter 1, she was pretty critical. I think she led me to believe that maybe she was overly critical of the political left in this country. She didn't have very nice things to say about the Trump administration's policy of deporting and separating families at the border going back to 2018, right? So again, these rights work except for when they don't. That was a creative interpretation, we'll say, on the part of the previous presidential administration. How about a right to privacy, right? We all understand that we have a right to privacy, but where did that come about? It's not in the Constitution. It's not in the Bill of Rights. It's a judicial creation by the Supreme Court in a case that went back to 1965, Griswold versus Connecticut. I've forgotten what the circumstances of that case were. I'm not going to ask you about it on the test, so don't sweat it. But what the Supreme Court did in the mid-60s was find the right to privacy among various amendments in the Constitution, having to do with free speech and freedom of government intervention in our lives, right? So privacy, good thing, right? How is this consequential to today? Well, it's because the right to privacy is pretty controversial. It was a precedent for the 1973 decision of Roe versus Wade, which in effect legalized abortion in all 50 states, right? And we can remind ourselves of the discussion maybe 20 minutes ago that had to do with freedom of religion, huh? And we're talking about this in Texas in 2021 all over again, right? So here we are. I have a feeling that the Supreme Court is going to have to weigh in again on Roe versus Wade, and I don't know. My gut tells me that things won't likely change very easily because change doesn't happen very quickly or very easily in this country, and Roe was decided in 1973, but who knows, right? This all stems from the Supreme Court coming up with a right to privacy that again is not a term that's used in the Constitution or the Bill of Rights. So to better understand the right to privacy, we this brings us back to Hamilton's Federalist Paper number 84, which is where Hamilton mapped out his fear that a Bill of Rights might actually end up depriving citizens of more rights in the future. Really boils down to a literal or interpretive reading of the Constitution, right? Hamilton didn't use these terms, but there are those who do this today. There are those who declare themselves really strict constructionists, or what we might mean literalists. They read the Constitution literally, and then there are those who view the Constitution as a living document, who are judicial interpretivists. To put this another way, literalists view the Constitution as something that must be read literally the way it was and applied accordingly today, even though it was written 240 some years ago. And then there are judicial interpretivists who view this, the Constitution as a framework, a guide, that we need to understand as a living document and try to best apply it to today's changing circumstances, right? Because again, abortion wasn't a thing in 1783 when the Constitution was ratified. The internet wasn't a thing in 1783 when the Constitution was ratified, right? So if we're going to refuse to redraft a constitution, I don't think there's any political will for that in the United States today, and I don't see there ever being such a will anytime soon. We got to figure out how to live with this constitution that we have today, right? So I personally feel that maybe judicial interpretivism is the way to go, but again, reasonable people can disagree on this, and there it is, right? But it gets tricky, right? I mean, reproductive rights again weren't a thing back when the Constitution was drafted, and they're not the only ones that fall under the right to privacy today. Right? The notions of a right to privacy have been used in the fight for gay rights at present, or say the right to refuse life-supporting treatment, which we do have. But taking that a step further, what there are laws that prevent doctors assisting in ending one's life, right? So, to what extent can the government intervene or make laws that infringe upon our privacy? I will point out, as I say here, used in the fight for gay rights, I don't remember the text here. I read it a couple of weeks ago, but there was a Supreme Court case, I believe in 2003, that decriminalized sodomy around the United States. I know this is a very uplifting lecture, set of slides here, abortion and sodomy and so on and so forth. But is pretty much there could be laws to make it illegal to have, for two men to have sex, penetrative sex, prior to that decision in 2003. And it was fundamentally based upon a clear understanding of right to privacy, right? So, when we're dealing with, who people want to be with and how people want to die, these are pretty important, right? And reproductive rights add to this. So, that we don't have a clear interpretation of what a right to privacy is, could be problematic in the future, right? And I see another test coming from Texas soon, right? So how about battling for political inequality? We're zooming out here, getting away from the Constitution, the Bill of Rights directly, and thinking more broadly about civil rights and political equality or lack thereof, right? So there's a pretty clear dilemma of equal protection. We can't deny that discrimination still goes on in this country. Varying types and circumstances for discrimination, whether that's based on race, gender, sexual orientation, so on and so forth. Clear case goes back to 1944. This is World War II. The Korematsu versus United States case was one brought by Japanese Americans saying, hey, the government shouldn't be able to intern us, particularly on the West Coast, during World War II. The Supreme Court basically said, yeah, we're going to let this slide, but the Supreme Court decision claimed to raise the bar quite high to define a suspect classification of people, which this suspect classification, based on a perception of threat, could justify unequal treatment. The Supreme Court claimed that the government must employ strict scrutiny and provide a compelling state purpose to justify any unequal treatment. But again, this went through, right? I mean, we know, hopefully you're aware um, of the World War II history of the United States interning its own citizens, right? People of Japanese descent and US citizens of Japanese descent living in the United States during World War II, right? So, as we know, going back to the founding, equality has been very unequally and unevenly applied, right? So, a few things to know about this scheme here. There's a different scrutiny level for gender. It's kind of a double-edged sword of becoming a suspect class. I think we've moved. I hope we've moved on from this. I don't think there'd ever be a case where the Supreme Court would decide that, we could create, uh, we could accept some sort of level of scrutiny to treat people of different genders differently. Sexual orientation, of course, is a classification that is in flux. So this might be it has been, if you think back to proposed laws to um, try to limit people's access to public bathrooms that have been circulated in various states in recent years. I don't think we're going to see the Supreme Court decide that a different scrutiny level is acceptable for decisions to be made that affect people based on their gender. However, there's a continuance of de facto discrimination that is undeniable. I do like the fact that the text uses these terms. It's more Latin for you, de facto versus de jure. And I'll mention these two terms again down the road. But de facto is just a fancy word. The word fact is there. It means in practice. There's in practice discrimination versus de jure, which is a fancy word to say legally. Legally, discrimination should not exist in this country, but we all know that it does, right? And this goes back to what some people claim enslavement as America's original sin, right? This was a creation of narratives, perpetuated inequality that has manifested itself in today's society, perpetuating enduring stereotypes. And it was, again, I mean, this was the narrative at the time. Thomas Jefferson was talking about, God-given rights that were clearly denied to pretty much anyone who wasn't a white male who owned property. Right? We often omit that fact. I think I mentioned this last time around too, but it's that property holding. It was wealthy white men who pretty much only could exercise the full, basket of rights that the Constitution and Bill of Rights offered, right? And of course, by the 1860s, the country was neck deep in a civil war that was fought over the question of enslavement. The 13th Amendment was passed after, at the end of the at the end of the Civil War. Sorry, not thinking straight. That was meant to abolish enslavement. But many states, southern states, responded with what were called black codes that were in effect there were laws that were meant to recreate the conditions of enslavement and keep people, keep African Americans as second class citizens, right? The passage of the 14th and 15th Amendments were meant to end the black codes and better ensure equality. But the South responded, particularly the South responded with Jim Crow laws, which were fancier legal maneuvers that were meant to prevent voting on the part of African Americans and ensure segregation of the races, right? And it took some time, despite the laws, again, the laws de jure, the 14th and 15th Amendment, legally de jure, were meant to ensure equality, but de facto, inequality reigned, right? So how did African Americans fight for equal rights? Through the courts, through public boycotts, through trying to shape public opinion, which included public opinion of white Americans, and then lastly through Congress, right? It took about 100 years from the end of the Civil War for Congress to pass the Equal Rights Act and the Voting Rights Act, done in shortly after the death of Kennedy, when Lyndon Johnson, a good Texan, was president. I don't know if he was a good Texan, but he was a Texan. And I listed these things intentionally in this order because the court system is arguably one of the better ways to affect change more quickly in this country. And then boycotts and public opinion, by boycotting anything, political consumerism, you're meant to try to hurt an oppressing entity in its pocketbook, and then by public opinion, you want to get people on your side, which eventually will sway in elections. Hopefully, is the intent. And again, at the time, in the middle of the 20th century, lobbying Congress full of white men to make laws to enforce equality, the 14th, 15th Amendments in practice was a tough road to hoe, and again, didn't happen until the 1960s. So did the civil rights movement eradicate de facto discrimination as well as de jure discrimination? Of course not, right? De facto discrimination existed in the North and in the South, pretty much everywhere, right? As a response to the effects from attempts at integration. Obviously, you can't legislate racism away, and this is in effect, the definition of white privilege. The fact that you had an overwhelmingly white Congress not willing to give up, viewing equality on the part of African Americans through a prism of a zero-sum game. That somehow, if African Americans were given equal rights, that was somehow going to prejudice whites, which is, I think, preposterous. I think I can say that without that being very controversial today. But there we are, right? Continuing on here, does the United States still have a race problem? I think that's pretty safe to say. This is going to be one of the themes, if not the overwhelming theme, of the 13th film. That we clearly live in a radicalized society or racialized society to this day, and for many radicalized as well. Systemic racism still exists. I mean, you were young when Obama was elected. Congratulations. I was in graduate school by that point. And yeah, I mean, for all the talk of a post-racial society, that was a term that got thrown around a lot in 2008, 9, 10. Certainly not the case, right? I mean, we can easily, without Trump bashing, point out some pretty controversial things that the guy said that had to do with race, going back to the election of 2016, and even before that. You'll see he makes a cameo appearance in the film, going back to a case in the 13th film that you're going to watch, going back to a murder that took place in Central Park in New York in the 80s. That was totally racialized, and he was a bit of a protagonist in the case. I'll leave it at that. You'll see it in the film. But moving on here. Are African Americans the only people of color who face discrimination in the United States? Of course not. I take umbrage often when people say that slavery, enslavement is the original sin of the United States. The original sin, obviously, was systemic genocide against indigenous peoples, right? Against Native Americans. We see this today. We see discrimination against Latinx people, Latinos, whatever term you prefer, Asian Americans. Very much been in the news in recent months and years. There's definitely variations in the ease of assimilation, which is a term I don't love. But I mean, I mentioned my wife is not a U.S. citizen. She's from Venezuela, which of course is in South America, but she's very, very white. Her grandparents were from Italy and Spain. Her English is very good. So she doesn't quite. Her pathway to assimilation has been much easier. We'll put it that way. So, but that's not the case for everybody from Latin America. It's not the case for everybody from Venezuela at all in this country, right? So, this is just a consequence of the racialized society we still live in, for better or for worse. I would argue pretty much for worse. How about the case of gender? Remember these self-evident truths that all men were created equal? We know that women didn't get the right to vote in the United States until 1920 in the 20th Amendment to the Constitution. And there's a pervasive, unrecognized, and culturally rooted discrimination against women to this day, a lack of rights for women. Which is the influence of narratives, political narratives on women, the weaker sex, the fairer sex, whatever. But you had a movement that started well before 1848, but the Seneca Falls Convention was a meeting of women who advocated for full voting rights in this country. And again, that didn't happen until 1920, right? My great-grandma was born in 1908. She's passed away, but it baffled my mind one day when I realized years ago that my great grandma was born at a time when she couldn't. I mean, she couldn't vote because she was underage. She would have turned 18 by or 21, which was the voting age at the time. Um, Later, but she was a woman living in this country for a number of years when women still couldn't vote. And she lived to be 97. We talked about these things. Anyway, shifting gears. So the 19th Amendment, 19th Amendment, not the 20th Amendment. 19th Amendment was the amendment that won women equal voting rights. But that was it, right? Only guaranteed the right to vote. Beyond that, the Equal Rights Amendment has not been ratified. There is no amendment to the Constitution that says discrimination on the basis of sex is not allowed. It was first proposed back in 1923, so not long after the passage of the 19th Amendment, passed by both houses finally, a different version in 1972. And remember, how to get an amendment passed, you need 2/3 of both houses of Congress. So that's saying a lot right there, but it failed in the states. Couldn't get 3/4 of the states to ratify an Equal Rights Amendment. So there we are, right? And we can talk about the existence and persistence of the glass ceiling that exists in this country today. A term you maybe have heard. It came up a lot in the election of 2016 with once Hillary Clinton won the nomination for the Democratic Party. But, we often say that one ascends the corporate ladder, the political ladder. Women often eventually hit what we call a glass ceiling. They can look through the ceiling and see the men in the floor above them, but they can't break it. They can't get through. And that is, I think, still true today. So these are my last two slides. I think I got this and one more. Simple question that isn't simple at all. Why do inequalities of power still persist? Right? Well, it's because pervasive racism and systemic gender bias both still exist in this country, right? And these are based on unconscious stereotypes, and the existence of implicit bias. That even folks like me, white guy who views himself as pretty open-minded and understanding, there are probably things that bounce around in my brain that I'm not even aware of. That's just a consequence of living in a hyper-racialized society that's treated non-white people and women as second-class citizens, right? We got to get around that. We just have to get around that as individuals. And I mean, we can't really wait for Congress again to pass a law to make racism illegal. It's going to take us. And that was a point that I tried to make last time around as well. So what evidence is there that we are experiencing a reaction to social and demographic change? Our demographer friends tell us that not so far off in the future, whites in this country will be a minority group, which is to say there will be more people of color than white people in the United States. Gender patterns, again, are in flux. Summer of 2020 was one of social upheaval, which was probably scary for some people, but necessary for others, right? And I think the fact that the murder of, say, George Floyd was reacted to differently than the murder of Trayvon Martin. Granted, the circumstance was very different as well. But think about George Floyd when we watched the 13th, or when you watched the 13th film, which does discuss the Trayvon Martin murder that took place, I want to say maybe in 2012 or so. But anyway, there we are. For better, for worse, we can talk a big game about equality in this country and how the Constitution, the Bill of Rights, sought equality, but in practice, we're not there yet at all. Okay. So anyway, I'll leave it at that. Good luck on the quiz. Be in touch. Bye-bye.